Ladies and gentlemen, please welcome a powerful woman, a visionary, the lady that is steering the ship today. Somebody say wow.
No, I'm not going on the podium. I'll use the conference. Good morning, everyone. Welcome. We welcome you today, and I'm quite happy to see the public sector in one place because it's very unusual. Because when we ask for meetings, people are very busy. And of course, we're going digital, but sometimes we need to have both of a mixture so that we get to see each other on a face-to-face. So this is the background. So during time of COVID and some sessions or conversations that we are having, we found out that there was something that was very profound for me, where people are looking at data protection. So people say, what is cybersecurity and what is data protection? What are the solutions are you offering? But I said, maybe today, let's have a conversation around data protection. And most importantly, it appeals more to the public sector, because the government is also have been inclusive in terms of how the policies and how they should be able to govern data protection. So here we just want to have a conversation maybe to assist you in terms of your data protection strategy going forward. So as Liquid Intelligent Technology, I'm not here to sell anything, because definitely I know others when they are sitting there saying, what is Liquid going to be selling today? We are not selling. We are partners. I want to give value to you. So whatever conversations that are happening here, it's for your absorption, so that as you go and make decisions from an informed position. So today, let's be very engaging. There's a whole set of the team that is prepared for you, and then probably we can discuss about it. So from my end, data protection, what does it mean for me? What does it mean for you? Maybe let me just pick maybe Emma. What does it mean for you? I know I don't want you to answer me, my colleagues. I can see you're now looking downwards. I'm not asking you a question, I'm just posing. So definitely, let's have a conversation, guys, and let's be interactive. I really want to have feedback from you so that as we go forward, as we tailor-make certain solutions, how do we partner with each other? So welcome, everyone. I give time to the rest of the team. Thank you very much.
Somebody say wow. Now this stage is going to be used later on for you to get involved in, as she said, a conversation. It's not a lecture, it's a conversation. And as your teacher today, please take note that you have a notebook and a pen on your desks. You shall be writing an exam later on. So please take as many notes as possible. Also, can I be honest with you? Can I be honest with you, man? Can I be? There is no such thing as a stupid question. Let me repeat that. I thought you were going to say wow. There is no such thing as a stupid question. The Data Protection Act is new. Do you understand? It's something new. I don't have my head wrapped around it. I understand overseas, comparatively, there's things like GDPR and all sorts of pillars and areas that we need to be covering. But am I an expert? I'm not an expert, so I'm here to learn. I might even ask a question. So you must ask the questions that you need to ask. Please, whatever it is, jot your questions down. Your time is going to come where the spotlight and the camera is going to be on you. Is that okay with you? All right. Those of you that watch sports, I would like to congratulate one or two teams today. Let me just get my notes here very quickly. Thank you so much. I understand there was a cup final recently over the weekend. Is that correct? And I understand there was a team called Arsenal that was not involved in that cup final. There was also a team called Liverpool that was not involved in that cup final. Just to mention a few that were not involved in that cup final, where two excellent teams battled it out for 90 minutes and there was only one champion. This resonates in life, ladies and gentlemen, where you have many competitors, but at the end of the day, there will always only be one winner. I can guarantee you, if you want a partner for success, I've tried it, I've tested it, the only partner for success that you need is Liquid Intelligent Technologies. But how can they help you? I promise you, a lot of you in this room, in your organizations, you are only using part of what they can offer you. So today, part of the questions you need to be asking is, how can they help? So let me start off with some advice. To unpack the Data Protection Act, I'm going to call upon Vimbai Nikadzino. She is the Regional Head of Legal and Regulatory Central Africa. Wow. So, from a legal point of view, yes, come through, Vimbai, come through. Yes, I want to know. I know you will most likely answer all the questions. Please give her a wow. All right, Vimbai, over to you. We're keen to hear what this is and how Liquid ties in.
Thank you. Do I need to adjust this? Is this okay? Right. Good morning, ladies and gentlemen, once again. And many thanks to Arthur and to Loretta. Today we'll be talking the Cyber and Data Protection Act. Can I just get an understanding of our audience? Are we all technical people? No? We have a good mix? Okay, well, I just wanted to understand where to pace myself and know where to focus. But anyway, let's get into it. Just some background there on our process in Zimbabwe in coming up with our Cyber and Data Protection Act, which was driven mostly by developments elsewhere in the world. Arthur mentioned the GDPR, but where did that all come from? So you find all countries at some stage, at least all the advanced countries, had some sort of data protection laws that were in place. But as time went on, as technology advanced, we got to a stage where a lot was now happening online, and there was a lot of information online. And they looked and said, look, we need to make sure that human rights are secured, people's information is safe, and we need to put a responsibility on the people, the companies, the organizations that are collecting people's information to keep it safe, right? And then at that stage, that's when I think the pioneers in the EU was actually the EU in 2021, in 2018, when they came up with the GDPR, followed by the UK in January 2021. And from then on, because of the penalties that were put in place for those who don't comply, organizations were forced to now adopt what they call privacy by design, which is basically embedding privacy provisions in everything that they do to protect the information of the people that they are serving or that they collect data from. In Zimbabwe, we then caught up, we're not too far behind, in 2021 with the enactment of our own Cybersecurity and Data Protection Act. So it's still something very new, right, that we are all having to comply with. Just as an overview on my presentation, it's a long act, it's a big act, I'm not going to cover everything, but I am going to go through the objects, the application, and the key definitions of the act. I will talk through the general rules of processing data. I will talk through the duties and obligations of a data controller, a data processor, and the rights of a data subject. And I'll define those terms shortly. I will go through data breaches, the transfer of personal information outside Zimbabwe, offenses and penalties for those that breach the provisions of this act, the setting up of the Data Protection Authority and Cybersecurity Center and their functions in Zimbabwe. And finally, I will talk about key consequential amendments to the Criminal Law Codification and Reform Act. So basically, this one act is mostly centered on data protection, but it goes on and it amends our criminal code to make certain acts, to criminalize certain acts that relate to violation of data, that relate to use of computer systems, but I'll go into that as I unpack this. What were the reasons behind the act? In our case, in our country, to protect individuals' constitutional rights and to encourage a technology-driven business environment, because that's where the world was going, and that's where the world is still going. But as people use technology, there was a need to also make sure that they are lawfully using this technology and not infringing on other people's rights. It was also to increase cybersecurity, build confidence and trust in the generality of the public on the security of the information that they give out to us as organizations, as businesses. And to also provide, I think I mentioned this, a mechanism for investigating, collecting, and taking these cyber crimes when they occur to court. There's also the establishment there of a cybersecurity committee, which is something that actually comes out of an amendment which comes through this act, but an amendment to the Lawful Interception of Communication Act. So that's where that committee is relevant, and that's where it sits. What is the application of this act? Does it apply only to private corporations? Does it apply to individuals? Does it apply to public sector organizations? The answer is yes. This act, this piece of legislation applies to all organizations, individuals, and businesses. Because remember, at the center of it is protection of a basic human rights. And I will go into that a bit later. It also applies to all data controllers, whether they be individuals or organizations, to data processors and data subjects. Foreign entities that are not necessarily resident or incorporated in Zimbabwe but conduct business in Zimbabwe are also required to comply with this act and are required to nominate a local representative to be their data controller. And I will go into the duties and obligations of the data controller. So they are not immune to that as foreign organizations. They also need to comply. So the key definitions in the Act, it's got a lot. I just picked on a few to give context to our discussions. You've got the computer system there. I'm not going to read through that. Data itself, which means a representation of facts, information, or concepts in a form suitable for processing in a computer system, including a program suitable to cause a computer system to perform a function. I've been talking data controller, data processor, and data subject. Basically, the organizations we all work for are the data controllers. The people who process or work with the data or collect data from individuals are the data processors. The data subjects is everyone whose information we are collecting. Personal information, which is this data that we're trying to protect, means any information relating to an identified or identifiable natural person. This could include a name, address, phone number, your gender, your location, your marital status, physiological, genetic, mental, economic, cultural, or your social identity as a natural person. So the first stop is to define that personal information. Then the Act goes further to say what is sensitive data or sensitive personal information. And the sensitive data or personal information would include opinions about an individual that reveal their racial or ethnic origin, their political opinions, their religious beliefs, their professional affiliations, their criminal records, their health records, their genetics, or any other information that presents a major risk to their rights in terms of the Act, and their rights generally in terms of the Constitution of Zimbabwe. Processing, what does processing mean? It's actually an operation or any set of operations performed on personal data. This could include collecting it, recording it, storing it, adapting it, retrieving it. All that would constitute processing of personal information. Having said that, the general rules, the main rules on processing data can be summarized there. Data should be processed fairly and lawfully, right? Lawfully in terms of this Act, in terms of the provisions of this Act. That's what makes it lawful collection. And it must be collected only for specific purposes. After collecting it for those specific purposes, it can only be used to achieve the objects of the specific purposes that you collected it for. And when you're collecting data for a specific purpose, the data you collect must be relevant to that purpose. It can't just be, oh, I want all this information on this person because one day I might need it for something. No. It must be relevant at the time that you collect it. It must be adequate. It must not be excessive, right? Once you've collected it, you have a duty to make sure that the data that's on your records is maintained in an accurate manner and is kept up to date for, as long as necessary. Here, they expect you to take reasonable steps to ensure that the data is up to date. You must ensure that there are appropriate technical and organizational measures, and I'll unpack this a bit later, to prevent unauthorized access, alteration, disclosure of this data once you've collected it. So generally, the rule is when you collect any information since the enactment of this Act, you must obtain consent from your data subject. Yeah? You must obtain consent from your data subject. Such consent can also be withdrawn by this data subject at any time. And once they withdraw their consent, it means you can't use their data, you can't process their data. For sensitive data, I described it before, it can only be processed with written consent. Processing without consent is allowed in certain circumstances because, as we all know, we're all employees of our organizations and we've given sensitive data. So if it's to fulfill some lawful obligation that's covered under the Labor Act, under the employment laws of the country, then that sensitive data can be processed without your consent. Although where we are moving to now, you find that you need employee privacy policies. So even your HR departments, as they are processing this sensitive data, need to adhere to certain policies in how they do it. Although they don't need to come to you every time for consent when processing it in the normal course of business. Non-sensitive data, that's the data that's not classified as sensitive, may be processed in some circumstances without consent when it is necessary for legal compliance. Legal compliance in this case will come because there's some law, there's some statute that actually says they must collect that data, or legal compliance may come because there's a court order that's been issued in the process of some investigation, some lawful investigation. Should that happen, then non-sensitive data can be collected without necessarily getting consent from the data subject. It can also be collected for public interest tasks, promoting the legitimate interests of the data controller or third party, or when it is material evidence in proving an offense. I've spoken about that one. So there are very few exceptions to when you collect data without the consent of the data subject. And in each of those exceptions, you need to make sure before you do it that it's actually covered in the Act as an exception. But otherwise, the general rule is you obtain consent from a data subject at the point that you are collecting information. Why are we obtaining this consent? So our data subjects have rights. The major right is the constitutional right to privacy. So, because they have rights, we need to ensure that we always adhere to the Act, we always obtain that consent. But I've just specified there some of the rights that they have. They have a right to information. Each time you're collecting information from them, they have the right to know, to be asked for that information and to consent to giving you that information. They have a right to come at any time to rectify the information that they gave you. If there are circumstances to change, or if there's something that they want to fix, they have that right. They have a right, even after giving you consent, to object to your using their personal information. They have a right to be forgotten from your systems at the end of whatever exercise you are taking their data for. They have a right to say, delete my data, and I want to be forgotten from your system, and you must enforce that. They have a right to data portability if they want to move their data. They have a right to object to the automated processing of their data. Now here, you may have cases where, as a matter of course, you profile individuals from whom you collect data from. And it's an automated process for profiling, and decisions come out of that automated process for profiling. They have a right to actually refuse to be bound by those decisions if they've been obtained through that automated profiling system. And we, as the data controllers, I think I've spoken about this, must oblige our data subjects on those rights. Having said that, so what are your duties and what are your obligations from a legal perspective as data controllers, as the organizations collecting the data, as data processors, as the people working in the organization and working with this data that we collect from subjects? You need to secure that right to privacy. This is where our systems, our computer systems, then come into play. This is where even our manual systems, where we have a hybrid of manual and electronic data storage, come in. You have a right, you have an obligation to secure that information, to make sure that it is safe from unauthorized access by individuals, that it is not lost, that it grants the data subject a right to access. And by the way, if you are storing this information in a technological manner, in an electronic manner, as technology advances, you need to ensure that this information is always accessible. So even as your technology advances or changes, you must have records of this information easily accessible to this data subject because they have a right to access to any information that they've given you. We as data controllers must process personal information lawfully and fairly. I'm repeating this process again, but in terms of the actual actions, it's you informing the data subject about your collecting the data, about your reason for collecting it, about how you will process it, and this is done upfront before you actually collect the data. Consent, I've spoken about that. You need to obtain consent. You need to ensure that the data is used for specific purposes for which it was collected. So even if you have data in your system on individuals that you collected for a purpose that they had previously given you consent for, when you decide to change the reasons why you're using this data, you have an obligation to go back to each and every individual and obtain fresh consent for you to use it for a new purpose. Yeah? And you must ensure that personal data is accurate, complete, and kept up to date. Here, as I said, you need to take reasonable steps to ensure that. And you must also make sure that you have systems that protect this data against unauthorized access, loss, or destruction. Organizations, the Act actually says you need to take appropriate technical and organizational measures to protect this data against unauthorized access, loss, or destruction. And then you may ask, how do we do that? On the one hand, there's use of technology, encryption, access controls, regular backups. On the organizational controls, this is basically coming up with policies, coming up with procedures on how we collect, how we access, how we update, how we obtain consent for all the data that we are collecting. Privacy policies that are outward facing your outside stakeholders, facing your employees. So it's all those policies and procedures that you are now having to craft as organizations to bring yourselves to compliance with this. You need to train your employees to understand those provisions. Firstly, the provisions of this Act, the provisions of the policies and procedures that you would have come up with, and how to handle data. After that, you need to continuously conduct risk assessments to identify and mitigate any new risks or any areas that you hadn't covered before. And obviously, to ensure compliance with the obligations set out in this Act by any person working under your authority. And this applies also to your subcontractors. So we were saying work on policies, work on procedures. It even goes as far as amending your key contracts to ensure that you've embedded these provisions on data collection. How do you collect personal data? And how do you use it? How do you process it thereafter? You're required to appoint a data protection officer to ensure compliance of with this Act. So a lot of the hows generally in legislation are not in the Act itself. They come in regulations that then follow. So you find things like appointment of the data protection officer and the real hows, how do you do this and how do you do that, are going to be governed by the regulations. Sometime last year, we got draft regulations for this Data Protection Act, just to give input on what the provisions were. So it's not final at this stage, but that piece of subsidiary legislation will govern things such as who qualifies to be a data protection officer. It will cover things like licensing. Apparently, you need to be licensed as a data controller. There's tier 1 licensing, tier 2, tier 3, and then there's a special license that applies to all public authorities, and I think we are public sector. So we are mandated to go and get licensed should that piece of legislation come out the way that they've proposed it, you would need to get a license. There are nominal license fees that you would need to pay for the license. And for this data protection officer, that's why I paused here, they have key competencies that they've actually put there that they are proposing, that this person must be a person who understands this act, who understands how data is processed in your organization, who understands technology, who can be held liable if there are data breaches in your system. This is not a light role, because they're actually saying this data protection officer will require training and certification on an annual basis. That training and certification will be conducted exclusively by the Data Protection Authority, whom, as you know, is Portras. So this is going to be something quite serious. You know, people may fail exams and have to rewrite, but you need to appoint the right people to those positions and keep their certification renewed on an annual basis. You will have to advise data subjects when collecting data directly or indirectly from them of your name as the data controller, your address, the purposes of your processing that data, and whether you are collecting that data because you are mandated to do so by some law. I'll give an example of the telecom sector, and maybe the banking sector as well. We're required to obtain certain information from all subscribers in our industry. And this is a requirement according to the Act, the Postal and Telecommunications Act, that says you need certain details of your customers. So when we collect that data from individuals as Liquid Intelligent Technologies, that means we need to advise our data subjects that we are collecting it for regulatory compliance. It's in compliance with that provision. You will need to provide supporting information to the data subject at the point of collecting to ensure fair processing and advise and categorize your data so that you know who the recipients are. The authority may specify additional requirements here, and that's where those regulations start coming in, where they start bringing additional requirements from time to time, depending on what they would have assessed as necessary in the market. And obviously, when in doubt at all times, please seek guidance from that authority and direction. So what happens when you actually have a data breach? There's been unauthorized access, information has been lost, there's been alteration, unauthorized disclosure of information. That's what the Act calls a data breach. What happens when that happens? We have an obligation as data controllers, all of us in here, to report that data breach to Portras, the authority, within 24 hours of it happening. And those same regulations, draft regulations that I was talking about, have standard forms, including a form that you will use to report such data breaches, and the sort of information that you need to put on that form. Information about what security measures you had taken, how did this happen, what remedial action are you taking now to stop this from happening again. So at this point, we don't have those regulations in place. We just have that obligation there to inform Portras within 24 hours. Okay. I thought to also touch on the transfer of data outside Zimbabwe. This is also a provision that's in the Act. And transfer of third-party data to other countries is allowed. If you have an organization such as Liquid, where we have a group structure and we have other companies outside Zimbabwe, it's also allowed, on condition that the country where we are sending this information also has adequate data protection laws in place. That's a major condition. They must have data protection laws in place. In the event that they don't have data protection laws in place, you are allowed to transfer the data outside Zimbabwe, but you must make sure that you first obtain that consent from the data subject. The reason for your transfer must be to enable the data controller, which is the organization, to sign maybe a contract with external parties where it serves the interests of that particular data subject. So there are certain limitations like that where you are allowed even to a country that doesn't have these special laws. And you're also allowed for public interest grounds. And if the transfer is from a register that's open to consultation by the public, maybe in your sector, you may have that sort of information, those registers that are open to the public where people can come and inspect certain details. You are allowed to transfer that to countries that don't have existing data protection laws. So assuming there have been data breaches or unauthorized access to this data, what are the penalties that are in the Act? To begin with, any employee, contractor, or subcontractor of the data controller who violates this Act may be fined up to a level 7 fine, which currently is $400. As you know, these levels of fines change from time to time. So it's currently at $400, or imprisonment for a period up to 2 years, or both the fine and imprisonment. Any data controller, their representative or agent, who violates certain sections of the Act. Yeah? So it's different levels, different sections. Certain sections of this Act will attract a level 11 fine, which is currently $1,000, and imprisonment for up to 7 years. And after conviction, the court may order the seizure and deletion of any data containing media that may have been used in the committing of this crime or offense. Okay. And then to just wrap up this data protection section, I was talking about POTRAs, but obviously that's the designated data protection authority, and their duty is basically to regulate data protection functions in the country. That's why I was saying, when in doubt about any process, you can go to POTRAs and consult on how to handle the situations. Okay, I see people are taking pictures. Let me move on. Okay. And then we have the Cybersecurity Committee. I spoke about this, for lawful interception of communications. There's this committee that's been set up to advise the minister, and the minister in this case is the Minister of ICTs, on cybersecurity matters. Okay. As far as I know, this committee has not yet been appointed, so this is something that may be coming soon. Then we have some consequential amendments to our criminal code. These became necessary because these offenses didn't exist before from our criminal law perspective, and this act had to actually mention, criminalize them, and give penalties for those type of offenses. So here we see an amendment of the criminal code to include these offenses that are there: hacking, phishing, other crimes, unlawful acquisition of data, unlawful interference with data or data storage mediums, unlawful interference with computer systems, unlawful disclosure of data codes. And I just want to highlight this one, where there's an unlawful disclosure of a data code, and it involves an essential service provider or a national security provider. You find that for all these other penalties, for all these crimes, the penalties have either a fine or jail term, and can be both applied at the same time. But for this particular crime, it's a strict 10 years in prison without the option for you to pay a fine. There's unlawful use of data devices there, And the Act goes into what it terms aggravating circumstances. So you find those jail terms that I've put there, for the most part, are minimum terms. But when you commit an offense and it's deemed to be done under aggravating circumstances, the penalties are a bit stricter than the starting penalty. And for aggravating circumstances, this is where you violate computers or networks owned by the state, owned by law enforcement, owned by defense and prison authorities, even statutory corporations. If there's violation of computer networks and systems in a statutory body or local authority, then that is deemed an offense committed under aggravated circumstances, and they carry higher penalties. I thought this might be of interest to you, as you're most likely statutory bodies in here. There are also crimes relating to electronic communications and materials, such as transmitting messages inciting violence or damage to property, threatening messages, cyberbullying, harassment, false data to cause harm, spam, intimate images without consent, racist and xenophobic material, and identity-related offenses. And you can get up to 10 years in jail for that. And then there are offenses against children, a definition there on child sexual abuse material, quite a long one in the Act. But basically on the children there, if you produce, distribute, procure, bait a child into producing child sexual abuse material, pornography, then those are the jail terms that apply, 10 years, and just exposing a child to pornography, not necessarily engaging in any acts, exposing a child to pornography is a level 14 fine, 5 years imprisonment or both. Okay, so basically, those are the key provisions of this Data Protection Act. This is the law. You would have noticed that I said there are technical and organizational measures that you need to take for you to comply with this act. If I were to borrow from the Green MC, he said his word was wow. Mine would be compliance. Right? So compliance is what's key here. On those technical measures, I have my colleagues here who will unpack what you can do as organizations to make sure that you are storing data, protecting data in a way that is safe, that doesn't allow for unauthorized access, deletion, tampering with that data. That's where my technical team comes in. On the organizational measures, as I said, those are the policies and procedures that we are going to need to take in our organizations to ensure that we are compliant with this act. And I did advise that when in doubt, it's best to approach Portras on those policies and procedures and the processes that you want to undertake from time to time, and get their express approval before you engage. So thank you, ladies and gentlemen. I'll hand this back to our MC.
Wow. Thank you so much. Phew. Somebody say wow. I want to jump on this immediately. Compliance, she said. All right. Compliance, right? Everyone say compliance. Hi, baby. You know, how's your day going? No, it's fine. It's fine. I'm here with my colleagues from the public sector. Yeah, you know that liquid function I said I was going to. Yeah. Yes, that one. No, we're not talking DDoS. No, we're talking about something very important. I just wanted to run something by you, baby. You know how you got my Facebook and Instagram passwords? Are you sure I consented to giving you that information? Are you sure? Okay, but are you licensed to have that information? No, baby, this is not about anything. I just want to make sure that you and I are in a safe space. Yeah, and I love you. No. If you are compliant, baby, I've got no problem. No problem. You said can someone take these notes? No, I'm not talking to you. Okay. Can you write this down for me? Can you write it? So, baby, you said I gave you the password on which date? Yeah, just check your WhatsApp. I would like confirmation as to when I gave you the password for my social media profile. Yeah. At Facebook and Instagram, yes. Yes, no, it's small issues. All right. So if the missus is not compliant, does the $400 come to me that she has to pay? It goes to the states. Okay. You see, I'm on it. You see? You can call your partner now and just check if they if they got your consent. No, but on a serious note, ladies and gentlemen, I want you to take some time. We're going to take a 5-minute break, but the break is going to be special. You'll stay on your seats. We'll divide the tables into two. I would want a minimum of 2 questions per table. So this is an opportunity for you to engage. There's liquid stuff on each table. Just have a discussion with the person that's sitting across from you or sitting next to you. Come up with 2 questions per table. You can have more than 2 questions if you like. But just have a conversation based on the previous presentation. Have that conversation and maybe you can come up with some questions amongst the tables over the next 5 minutes, because remember, we're coming to this section where we're going to have the Q&A and we're going to ask all the questions that we need to ask from you. Is that all right with you? Thank you for nodding your head. Well, make sure the cameraman is focused on you the next time. All right, so we're going to take a 5-minute break. Mr. Sound Engineer, if you can play some music in the background. During that time, if you would like to get, I think the tea and coffee is still available. You can make your way there, but it's only a 5-minute break, and then we will resume with the program. All right. Mr. Sound Engineer, over to you.